Okay. Good evening. I'm Laura Miller. I'm the Volunteer and Community Engagement Manager for JustDane. It is JustDane's mission to help transform individual lives and social systems to create a just and equitable community. Our community engagement team is super excited to welcome you to the third session of our 2022 Just Conversation series. We envision this series to engage our community in discussion around important, timely issues that affect us all. And our hope is to keep these sessions in more of a conversational format and focused on creating solutions as opposed to restating the problems. Thank you so much for being here tonight. We'd also like to express gratitude to CUNA Mutual Group for their generous sponsorship of our 2022 Just Conversation series. Some logistical items first. We're streaming this live on JustDane's Facebook page. If you're joining us from there, welcome. Please feel free to drop some questions in the comments. And if you're right here with us on Zoom, welcome. Feel free to drop your questions right in the chat. I'll be monitoring both of those, and we'll try to use the last 15 minutes or so to answer some of the questions that haven't been addressed yet. So tonight, we are honored to welcome to Just Conversations 3 candidates for Dane County Circuit Court. We have Judge Nicholas McNamara, Attorney Dianne Schlipper, and Judge John Hyland. JustDane's Board President, Payal Khandhar, is here tonight to lead the discussion as we get to know each candidate, their role and the role of the courts in the criminal justice system, and how this role can or cannot impact some hot topics that we've all been hearing a lot about, such as bail reform, public safety, jail conditions, etc. Thank you very much to all of our guests for joining us tonight. And also a big thank you to all of you for being with us here tonight. I will now pass it off to Payal to get the conversation started. Payal?
Thank you, Laura. As Laura said, my name's Payal Khandhar. I am a local criminal defense attorney, and I am the board president of JustDane, and I have been for the last 3 years or so. So I'm excited that we have these candidates here. I'm excited that people are interested in learning more about the judicial candidates. I think this is a rare opportunity that people have to ask questions directly to people who are on a ballot. And so I'm gonna go ahead and get started. I'll just call on folks so that we're not talking over each other. But if you can just start off with just introducing yourself, and with that introduction, if you could let us know, why did you become a judge or a judicial candidate? I suppose if you're currently a judge, what is it that's motivating you to stay on the ballot and continue in that role? Let's get started with Ms. Schlipper, since you are the newest person potentially joining the judiciary.
Certainly. My name is Dianne Schlipper, and I am currently running for judge in Branch 3 in the Dane County Circuit Court. Judge Valerie Bailey-Wrinn is currently the presiding judge, and she is retiring. It's worth noting, especially for me, that it is an uncontested race, and obviously the election is April 5th. As far as why I am running for judge, on a large scale, I made a career commitment to public service a long time ago, and I believe in justice and the systems within which we work to achieve it. I think it's worth spending just a minute or two on my background, as it's really connected to why I'm running for judge. I spent the first decade of my career as a child welfare social worker. I worked with families and children during some of the hardest times of their lives. The families were facing issues related to trauma and addiction, mental health crises, abuse, poverty, incarceration. And I spent countless hours with these families in their homes, really building a trusting relationship. And during that decade, I really got a sense for what people were struggling with on a day-to-day basis. As a therapist and an advocate, I was trained to listen and to assess and to support, and also to make well-reasoned, articulate decisions. People weren't always pleased with my decisions, but usually, given my transparency and honesty, they could kind of understand where I was coming from. As an attorney, I chose to, much to my own surprise, I chose to become a prosecutor. I was in the DA's office, and currently I work in the U.S. Attorney's office. And I chose to become a prosecutor because I think both my judgment and my discretion can have really profound impacts on individuals and families and communities. And I thought I could do some good, bringing my empathy and some perspective about those struggles that I had mentioned that people face every day with trauma and addiction and all those other things. Both that perspective is, I think, really useful when making charging decisions and also sentencing recommendations. As a prosecutor, in my current job, I started out as a reentry coordinator, so I gained a significant amount of perspective and insight into the struggles that folks who are getting out of prison face. And so I think both of my careers have really prepared me for this role. I've always strived to do the right thing by my community. My community includes victims and survivors, but it also includes defendants and everyone in between. And so I think I have a really unique perspective. I've seen what happens on the other side of judges' decisions, both before and after. And I'm looking forward to putting all of that experience to work to serve the public fairly and impartially as a circuit court judge. So, thanks.
Thank you. And Judge McNamara, if you want to answer next.
Thank you. I'm Nick McNamara. I'm here in my office in the courthouse right now. I'm currently the judge in Branch 5. I've been a judge since July of 2009. And currently, given some retirements and so forth, I'm the second longest serving judge in Dane County with about 13 years or so. I started law school, and in law school was able to do work with on behalf of people with disabilities. I had my dream job as an intern or staff attorney for what was called then Coalition for Advocacy. It's now Disability Rights Wisconsin, working with leaders of disability rights that are actually national leaders, or were at their time, people like Dianne Greenlee, Tom Dixon, Lynn Breedlove, Roy Fremming. And as I was getting close to graduation, I begged them to give me a job for minimum wage. They just didn't have anything available. So I went to work in the courthouse as a staff attorney, working with great judges like Susan Steingast and George Northrup. And then Judge Steingast and I both at the same time joined a private law firm called Habish & Rotier. And I, for 16 years, was there doing plaintiff's personal injury work. I loved doing that work. I was able to help regular people. They didn't have to be wealthy or poor one way or another. They just had to be people who needed a chance in a day in court because of an injury or a loss of some sort. I did that for 16 years. I tried 55 jury trials as a lawyer, which for civil lawyers is more than average, and really enjoyed it. I was ready for a career change around the beginning of 2009, and was either going to open my own law firm, but then Governor Doyle announced 3 openings in Dane County for appointments. If he had said 1, I would have probably looked the other way. If he said 2, I don't know. But he said 3, and I thought I might have a chance at that. And I was lucky enough to apply and be appointed by Governor Doyle, and then reelected the following April. Since I've been a judge, I've almost exclusively have worked on criminal cases, which is only interesting a little bit because I never did that as a private lawyer. But I did do a lot of trials, and criminal judges do get a lot of trial experiences. I think I try to keep track, but I think it's around 175 jury trials as a judge now. And the criminal cases are absolutely the most interesting and compelling, the most important, I think, with for individuals, individual lives, and the community as a whole. So although it took me a little while, even though Dianne has been working in public service pretty much her whole career, I did take that 16 years sort of for private work. And now I've been given the chance to return to what does feel like public service. And I'm really humbled to do the job. Thanks.
Thank you, Judge McNamara. And Judge Hyland?
Thank you very much. My name's John Hyland. I've been on the bench in Branch 14 since my election 6 years ago. And before that, I practiced law for 27 years. My first career was actually as a teacher, but I decided to change. And I was fortunate to fall into a firm that needed an associate, and I stayed there for 27 years, focusing after the first few years on criminal defense and drunk driving defense. About the last 8 years of that period, I was living in Wanakee, and I ran for the municipal judge seat and won the election, and I served in that seat and kind of came to believe that it was a better fit for me in the sense of temperament and what you could do to assist people. One of the things that not every municipal court deals with, but this one did, was juvenile delinquency and school truancy. And so there was some really hands-on opportunities with youth as far as trying to encourage their behavior, encourage their participation in positive ways, as well as all the other citations that come before a municipal court. I had begun to feel a little bit burnt out, and there was an open seat to which I applied, but Scott Walker was in the governor's office, and I had signed a rather infamous petition that he took exception to, so I didn't get appointed. But then the following summer, there was an opening, and 2 people decided to run, but then a second opening opened up, and then a third person decided to run, but then a third judge retired. So Judges Bailey, Reen, Mitchell, and myself all managed to run uncontested elections and get elected. And I've been happy and fulfilled in what started as a juvenile rotation, but moved into a criminal rotation for the past 5 years. And that's been where I've been plying my trade from the bench and trying to make an impact in the community, not just on behalf of one client as I did as an advocate in criminal defense, but on behalf of everyone else, and still trying to touch individual lives as they appear before me. But there's certainly a large number, a greater number than I was able to try and impact just as an attorney. So I'm happy to look forward to being elected in April. I hope to serve out the full 6 terms. That'll take me to age 70, and I think I'll retire at that point. But I still have a student in high school, so it'll be nice having a good solid income for a while as well before I give up this exciting adventure. Thank you.
Thank you, Judge Hyland. And I think I'm going to just go back in reverse order here. You talked about this a little bit, and I'm hoping, I practice in front of you. The other judges are in the courthouse all the time. Ms. Schlipper's in the courthouse, but I'm not sure that, the general public really knows what the role of the judiciary is, in the system and then also in the community. Can you just give a little bit of an explanation of the role of the judiciary?
Sure. And I'll focus a little bit in the criminal side of it, but this is also true in juvenile law. When people are accused of violating laws, then they are brought before courts, and eventually cases come to a resolution. There may be a lot of steps throughout that process involving challenges to evidence, challenges to steps taken during the investigation, and so forth. But in the end, we see the cases most often when they come before us for either a negotiated settlement or a settlement where a plea is being entered, but there's some argument or perhaps total argument about what should happen next, or for a trial. And if there's a conviction, then a sentencing. Now, unfortunately, a lot of what we have to do comes at that point at the end. But I know, at least for me, what I try to do is speak to every defendant, no matter what the case is. If they're in front of me and they're becoming convicted of whatever it is that they have admitted to doing or been found to have done, I try to have an impact through what I can do in the sentencing and in speaking to them to try and influence and either encourage them, counsel them, correct them to the extent and to follow the rule that the judges have to follow, which, if there's a conviction, to use the least restrictive confinement or least restrictive sentence that does not unduly depreciate the gravity of the offense. So we really, we serve both to ensure that what's being prosecuted and resolved through negotiated pleas are appropriate, because we don't have to follow things if it does not seem to serve the interests of the community, but also to try and determine how best to correct people's paths, I guess I'll say.
Thank you. And Judge McNamara, if I can direct this next question towards you, because I know we've had these conversations before. So as a judge, can you take positions on political issues or controversial issues?
That is a bit of a dilemma, and also pretty much a fuzzy question because, or has fuzzy answers. We're nonpartisan judicial officers in Wisconsin at every level, and there are limitations on what we can publicly say or do that would be partisan or seen as overtly political. But each of us are allowed to kind of draw the line where we see it fits best, and that kind of shifts over time. Some are a little looser with it, others a little more confined. It's complicated because, you know, we're community leaders. We're in a position of authority and responsibility that has to be representing the entire community, but at the same time standing up for fundamental values, principles, not just constitutional, but just basic human rights. One of the rules of ethics for judges is to not be swayed by fear of public clamor, I think is the word, or outrage. And yet we are elected officials and need to be somewhat responsible or responsive to the community in positive ways, at least. But sometimes it does require us to make decisions that are not popular. And I know Judge Hyland and I both have been involved in it, and I know Judge Schlipper will herself as well. It just goes with the job. So yeah, there's current events and interesting things happening, particularly in criminal justice that the legislature is involved with. We could certainly help inform the community, the public, and say, well, if you're going to change bail laws this way, this is what the data looks like. This is how we're doing it now. It would probably be inappropriate for a judge to say, and I don't think you should do something, or I think the legislature should do so. That's probably going too far. But it is important because many of us, including myself before I became a judge, know very, very little about what actually happens in our courtrooms and the procedures. We think we know, but there's much we don't. And that's setting aside all of the substantive facts about a particular case, which we don't know because we just read summaries very often just in media or whatnot. So being a source of hopefully reliable and neutral information is a good place for us to serve a reasonable role in all of these important current discussions, I think.
Thank you. And like you said, Judge McNamara, different individuals are going to draw their line in different places. So I do want to open this up to both Judge Hyland and Ms. Schlipper to see if you have anything else that you want to add to that question.
Defer to Judge Schlipper, and then I'll be happy to join in.
Well, I have a lot to learn. So, I have been a part of a lot of meetings and interviews and, campaigning. And so I keep rereading the kind of judicial code of conduct for guidance on a regular basis. I guess I'm not entirely sure where the line is. I look forward to discussions with the judges who've actually been doing the work for a while. I think this is a little kind of maybe going out a little bit further, but I think it's, again, I can't speak to specific parameters because I'm not in the job, but I think that it's really important for me when I think about being a judge if possible, to try to continue to have a pulse on what's happening in the community. And so, you know, for me, that looks, I'm not, though perhaps I should be, I'm not really much of a person who serves on a lot of boards, but I like to volunteer in ways that gets me out in the community, so that, because I think it's really important to, you know, just to be around people if you're going to be sitting in judgment. And so for me, that's kind of what, I guess that looks like. You know, I've been volunteering at a food pantry. I like that type of being in the community somehow. I don't know that it's directly answering your question, but I'm constantly struggling with what can my role as a judge be in the community, and not necessarily to advocate for specific positions, but to be in a position, I guess, to answer questions when the need arises. So
I appreciate you're talking about the pulse of the community, because I know there are certain subsets of cases that we see in criminal cases where the community is very much interested in what is happening. And so much of what we do in those types of cases, and I'll just pull gun violence out as an example. So much of what we do is done in a courtroom with the attorneys, the parties, court staff, and nobody else. You know, but yet I always imagine that what I say and do is going to have an impact out in our community, even if nobody knows about it, because I have to, in the process, balance that concern with what's appropriate given this individual person, their character, the nature of their offense, and so on. It's a little frustrating. I'm not saying I'd like everything I do in my courtroom to be spread out in the community so people knew I was trying to respond to things. But when you see criticism of things not happening, everything's a case-by-case basis for us. And so in each case, we may be able to make some point that might help people understand or help the community or help this issue within the community. But boy, all I think you can do when you're on the bench is faithfully say, this serves that purpose, this serves what I'm here for, without rolling over someone's individual circumstances, because everything is, like I said, a case-by-case basis. I think Judge McNamara talking about how there are unpopular things we do. I guess those are the times when somebody is in the courtroom taking down or understanding or reporting on it. And I know of a few of those where I've taken hits, but you have to do what's right in that case for that defendant with the consideration of what the community demands.
Thank you. And that takes me to my next question. So, you know, you talk about these cases, and there's definitely certain cases that get a lot of attention. But then when you actually get to a judicial election, it tends to be a pretty low turnout of people who are actually coming out and voting. So, I mean, Judge Hyland, I'll start with you. Why should the general public care about judicial elections in the first place?
You know, we should not ignore what our civil brethren do, what our juvenile brethren do. What the public should be concerned about is that they have people that they're electing who do care about the individual case, but also the broader community sense, the broader legal outcome. I'm losing the word, but the flow from what's done, what can happen the next time, or what this can influence from someone else. Obviously, there are some things that get into the newspaper, and people will be happy or unhappy as a result of whatever they read. But on a daily basis, there are judges in our county who are dealing with things, and they're incredibly dedicated. They're incredibly hardworking. And I don't know how, in looking at someone as a candidate, you decide whether that's true or not of this person, unless you get to hear someone like Dianne speak about her background and what she believes. But it's a little different than those people you vote for the Board of Supervisors or the City Council or the legislature, because you can call on them personally to do what you want them to do as a constituent. But we are, in a sense, the same thing. We just can't be accountable except, you know, this once a year or this once every 6-year election cycle. But I appreciate hearing from the public. I appreciate hearing if people think that that this is a problem in our community, because it tells us what we should try and respond to in the broader picture.
Dianne, do you want to answer that as well, or?
Sure. You know, when I was thinking about, I've had a couple of interviews recently, but I think sometimes, you know, the big campaigns get a lot of the turnout, but they actually oftentimes have, you know, a lesser impact than some of the smaller elections. I mean, circuit court judges preside over virtually all state criminal and civil actions, aside for some of the municipal things that occur. It's typically going to be the first and only experience that people have with the legal system. I don't claim to know a lot about civil law. I think I'm going to be learning a lot, but I know that, right, there's family law, there's divorce, there's child custody, small claims, contract disputes, eviction, landlord tenant. I mean, these are things that impact people every day in their everyday lives, much less criminal and juvenile justice. And so I think it's critically important to know who you're voting for. You know, short of probably marriage and adoption, nobody really wants to come to court that I can think of. And so as kind of, not even kind of, as the gatekeeper of that process, people should want to know our demeanor and our approach, and that they can maybe, you know, walk through a door feeling safe. And I know, well, I personally have already said it. I think it's really important as a judge to try and think about what those people are going through when, you know, as they walk through the door. Are they dealing with having to call in sick to work or get off of work, child custody issues, just pure anxiety for having to go through, and maybe, you know, an ex-wife has an attorney and I mean, there's so much that goes into it. And so I think it's really important to know who's on the ballot and who you're potentially voting for.
Judge McNamara, did you want to add to those responses?
I do a little bit, and just starting with pointing out that, you know, we don't have to have a judicial elective system. Of course, right now, very, very familiar to everybody involved here, I'm sure, is current nomination at the U.S. Supreme Court, which is an appointed. No federal judges are ever elected, and all federal judges have a lifetime appointment, which some people think is not a good idea. But there's a lot of concern sometimes about elected judges. There are some states, Illinois, Texas, many other states, where the judges are political partisans. They are the slate of candidates for one party or the other, and the voters respond one way or another, probably just on pure politics. Wisconsin, all judicial officers are elected. If a judge retires or is unable to finish the term, then the sitting governor does get to appoint, and then that judge has to run at the next election. But having elected judges is not without some controversy or costs. You need judges that are representative of the community, but hopefully the whole community, which is a very hard thing to do, and responsive to the community, but not beholden. And, you know, it's an interesting judicial ethics question that is a different conversation entirely. But once a judge becomes a judge, when should judges recuse themselves from cases that are before them? And in particular, if they've accepted money for a campaign. And that's a much more sharply focused issue at our Wisconsin Supreme Court, which is a little more political in its discussion, at least, or debates, and in the way party money flows, and not so much at the trial court level. But so it's complicated. I mean, we need judges, again, to be responsive, but, you know, and the people do have the right. I probably shouldn't do that in this conversation, but, you know, judges can be recalled. There was a Dane County judge in the late 1980s who was recalled by the voters. And Judge Moyer Krieger became the first woman judge of Dane County following that. I've never heard of a judge in Wisconsin or anywhere in the country, in the United States, face a recall because they were too harsh on a defendant. The public clamor typically is because they're concerned the judges are too lenient. And that's okay. I mean, judges need to own their decisions, but it often ends up being one-sided. One of the questions we had preparing, I don't mean to jump the agenda here, Ms. Khandhar, but was, what's the biggest obstacle or some of the obstacles in our justice system? And I do think one of them is that there is a very loud representation at media level and by some other actors in our communities who only view punishment as the goal of a criminal justice system and have completely abandoned thoughts of rehabilitation, reconciliation, restorative justice. And when judges start focusing on that, there's a loud voice yelling against us to do so. But we still need to be independent and still nonpartisan and neutral. These are our challenges, but they're challenges the whole community faces. And one last point on the federal judges. I mean, there was a time, of course, in the South when civil rights were and voters' rights were being, people were dying for them in marches and other demonstrations. And the local state judges and state juries were not convicting people who were committing atrocious crimes against civil rights leaders and people just seeking the right to vote. It was the federal courts, the appointed lifetime federal judiciary, that were the spearhead for significant positive changes. It doesn't have to be that way, but our system. So anyway, it's just important to remember there's these two options. We have elected judges here. There's pros and cons to it, and it's a good discussion.
And Judge McNamara raised obstacles, and it is one of the things we're thinking about discussing here. If you review everything that's been going on as far as allocation of funding, a huge obstacle I know for my juvenile justice colleagues, and to a degree to the criminal justice system, is the lack of funding for things that can assist with, as Judge McNamara says, rehabilitation, reconciliation, restorative justice. The judge can only order people to do what's available for the subjects to engage in, whether it's in CHIPS matters or juvenile matters, or quite honestly, even in criminal matters. A small example, there's some individuals who have a real preference for certified domestic violence counseling, that they believe that's the gold standard. It should be the only thing we order people to do on probation, but the Department of Corrections doesn't provide it. And it's expensive, it's hard to get into, and we don't have the resources for something as simple as that, let alone for addressing all of the things with younger offenders, juvenile offenders. Unfortunately, we can order things, but unless the resources are there for the people to act upon, it becomes a real obstacle to us trying to satisfy the public's desire for what they perceive to be justice, and to doing the kind of good that each person on the bench wants to see happen for each individual.
I think this is great. I mean, this is definitely one of the questions that we were planning on talking about. And so Judge Hyland, you answered it about what the obstacles are, and Judge McNamara, you touched on it as well. If you want to talk more about the obstacles, or I can just turn to Ms. Schlipper and see, I mean, what do you foresee as the obstacles of being a judge in the Dane County Circuit Courts?
This is where I get to say great minds think alike and hope it's true. But yeah, I mean, I sort of had a list of three, and my top one is that there's just not enough funding for services towards rehabilitation. My second one is, I have it as kind of a combination of people not trusting in the system, partially due to the over politicization. I can never say that. So again, with the, campaign finance, all that kind of stuff. And then I just sort of added to, I think the system is a bit clogged, I think, right? Swifter adjudication, and it's not a reflection on the judiciary. I think it's just the nature of post-pandemic, things like that. But I think people are kind of hanging out there just because there isn't enough space to get their cases moving forward. And so I listed that as the third one. So yeah.
On that point, we don't have enough lawyers. Honestly, that sounds like it could be an impossible thing to say, but it's absolutely true. Both in for the criminal rotations in the prosecutor's office and for the defense bar at all levels. And so we need more law. That's actually kind of one of our bigger constraints right now in terms of dealing with backlog of cases.
Is it actually, I don't know the answer to this, is it a lack of lawyers or like lack of funding for the lawyers? You know, like in.
Yeah, probably both. I mean,
I know the DA's office will tell you that they have openings they can't fill because they can't pay the people with a law degree and that education to pay for more than the city of Madison pays people to issue parking tickets. So it's that funding issue partly, and that there aren't the people there applying for the jobs either. And I think the public defender's office faces much the same problem. And the public defender's office has relied a lot upon private attorneys who are willing to take public defender appointments. And that has shrunk as well, partly because of the pay not being commensurate with the work, and partly because it's difficult work, and people would like to have more opportunity to be able to survive, I guess, on helping out in that kind of a service.
For the defense bar, of course, until about 18 months ago, Wisconsin had the absolute lowest compensation rate for private lawyers who agreed or contracted to take public defender appointments. So there's people who were too poor to afford their own lawyer, who had a fundamental constitutional right to a lawyer. And the public defender's office can't take all of them. Sometimes there's conflicts. Sometimes there's multiple defendants in a case. Sometimes there's just not enough of the staff in that office to do all the cases. So they depend on the private bar. Wisconsin had the lowest compensation rate in the whole country. I mean, along with, name any state that you might have a view about, and I won't do it because it's probably impolite for me to just say so, but Wisconsin was the lowest, so it doesn't matter. Whatever state you might think of, Wisconsin was right there. That's changed about 18 months ago. What is it, about $70 now is the rate? Still not enough, as Ms. Khandhar knows from personal experience, really.
Yeah, so the state public defender rate went from $40 an hour to $70 an hour. Just for comparison, you know, the county rate for when it is paid hourly is $100 an hour. And right now, I believe the federal public defender's office, I think that we're at $160 an hour. So a significant difference in state and federal defense. So that's, I mean, you know, there's the role of the judiciary in this and your perspective from that role, but I mean, what can be done to ensure that people get adequate access to legal help? Is there anything that can be done from your perspective or your role, or from a broader community perspective? Is there anyone who wants to volunteer to start? Judge Hyland, you're unmuted, so I'm turning to you.
I'm unmuted. Great. Well, okay. I've only been in this position for 6 years and only in the criminal for 5, but I have in the past year had to appoint attorneys myself for the first time on a number of occasions, because I guess it's hard for them to say no to the judge, and it is at the higher rate. It's not at the public defender rate, but the $100 rate. I don't know where that money comes from. I don't know how much money is there in the pot. I don't know when we'll start hearing from the county executive that we can't do this anymore, because we need to do it more and more. So certainly we can make it clear what the budget needs to be from the perspective of the judiciary through the clerk of courts or directly, but we need constituents to be telling their representatives that we want to spend more money on these things, more money on making sure people get good attorneys, that they get representation, that they get justice, and that there are resources to assist with things. That's what I think the voters can do when they have the opportunity, by demanding that of the people they're electing in those legislative and executive positions, because they control the purse strings.
So Judge Hyland, if you can just, expand on that just a little bit more. How does it get to the point of a judge appointing an attorney? And, can you walk the group through how we get there?
Anyone who's indigent and qualifies for a public defender will get an attorney through that program if they're fortunate by an in-house public defender, because they're excellent attorneys. But as Judge McNamara said a moment ago, there may be conflicts, there may be multiple defendants, there may be other reasons that the public defender office needs to find a private attorney that will take the case at the rate that they can pay. We have gotten, in the past year, 2 years, memos informing us that we've made 120 contacts and we still haven't found an attorney for someone. And in some cases, these people are still in jail for various reasons that we could address with discussions about bail. But in the end, if it has gone on so long and they're making no headway, then we have to decide, do we have to just take it into our own hands and appoint so that this person is not denied justice and his or her case moving forward?
Thank you for that explanation. And I know Judge McNamara, you want to jump in?
Thank you. So there is a system, a court system, criminal justice system, but the system, to some extent, are made up of a mosaic of just individual cases, and each case is one at a time, and inherent in every single case is a built-in natural dilemma or conflict between timely, efficient justice, so it's not delayed, along with sometimes careful thought, analysis for lawyers to file proper pretrial motions, such as constitutional challenges, an opportunity for trials, jury trials, which are very time consuming. And we can't be an assembly line, or we shouldn't treat cases and individuals, because they're people, both when they're a defendant or when they're on the other side of someone who's been harmed by conduct, maybe a victim. Then we can't just be an assembly line and just rush through it, but to be sometimes thoughtful, careful, takes time. And that's okay, but built in with that is, again, sometimes people are in jail pre-trial, which we do have a presumption of release currently in Wisconsin, and in Dane County, 81% of the criminal defendants do get signature bonds, at least at a study I finished a couple years ago. But it's always for that individual who's still in jail, who's innocent of the accusation at that point, even if there's one person that's doesn't feel fair to that person, and we have to deal with that. And also people who are outside of jail waiting for their day in court, they have sometimes very restrictive bond conditions. They're exposed to the risk of what we call bail jumping, because they might be accused of violating some of those conditions. So I don't have an answer. These are just part of our dilemma within our system, which is we want timely justice, but fair justice, which sometimes takes time and thought and care. And finding the right balance is the challenge. And hearing from good lawyers does help us get that done.
Thank you. Ms. Schlipper, do you want to add anything as to what can be done to make sure that everyone has adequate access to legal assistance?
No, I think that kind of dives into some stuff that within the courthouse that I'm not totally aware of yet. So I think that's, yeah, I think it, I guess I do. When I think about adequate access to legal help, I do think it, puts the judges in quite a bind, because then if somebody is pro se and remains that, so, it makes your job, it takes so much longer, because then you're always, we're always thoughtful, you're always trying to get to the right answer, but it means perhaps that you have to spend more time probing to get the necessary facts and make sure the legal argument is fully developed. And so I could see how that can just add more clogging to the system.
And when you're saying pro se, so someone going forward without an attorney representing them.
Yes. Yes,
Yeah.
thank you.
So I'm going to just change topics a little bit. I have a couple more questions. Then I know at 7 o'clock, we're going to open it up. Laura is keeping track of the questions coming in so that we can address some of those. So Judge Hyland, I'll start with you. So when you're making big legal decisions, what guides your thought process? Is there anything that you turn to in particular?
I have a magic 8-ball that helps sometimes, but no. You know, we all work within the realm of the law. First source the statutes, what the legislature has decided we have to follow. Second source the court opinions by the higher courts that have interpreted those statutes. Third resource is, unless it conflicts with one of those so clearly that it can't be justified, it's what you believe is the correct decision to make, the correct route to go, based hopefully, as Judge McNamara said, on good lawyers presenting both sides of the issue and laying it out so that you can tell that this path is legal, that path is legal. I got to find the one that meets the correct solution. And it has to be within the confines of what the case calls for. But sometimes there are decisions you have to make that reach the broader issue of what is correct as far as justice. A simple, quick example, in the Chandler Halderson case, there was a motion to have him not attend sentencing. And I had to do the research, and I discovered there were cases that justified both ways, defendants being able to waive that right, even in the face of statutes that said the defendant shall be there. And we had somewhat conflicting Supreme Court and Court of Appeals decisions on that. And in the end, part of what I decided was that I needed to deny that motion because I thought that the victims and the public had a right to know that he was present for that part of the process. It was, in my view, the right thing to do, and it didn't violate a constitutional right of his, because he was given the constitutional right and statutory right of being present, even though he wished to waive that. I didn't feel I had to permit that waiver, and that was the better course, even looking at it from an appellate standpoint. So it's that type of looking to the resources or the sources of the law and the guidance in those cases, but still we're making individual decisions in individual cases, and unless we're out of the boundaries of those, and will be reversed, hopefully, if we are, that's how the decision making goes for me anyway.
Thank you. And Judge McNamara, I'm sure that, the Constitution and the statutes, case law all guides your decisions, but is there anything else that you keep in mind or, part of your thought process in making big legal decisions?
So I have come to accept, I'll say even embrace, just the reality of my responsibilities as of being unsure. I never have certainty. Legal rules, legal principles, that's fair enough. But where I have a lot of discretion, and judges do have a lot of discretion. The biggest, easiest example is at sentencing. I have to be willing, I think, to accept the fact that I can't be certain, which leads me to be cautious and careful and not radical in a sense of doing something that's just shocking in some way, even to me. I was at a judicial conference, a judge from another county, but a colleague said to the group, and I'd already talked too much at the meeting, so I couldn't say anything, but he said that, and we're talking about this very discussion with judges and a kind of an educational thing. And he said that when he has an important decision to make, he thinks about it, which is good. And he prays about it, which is okay. I mean, each of us find our sort of peaceful, contemplative place in meditation, prayer. Those are personal habits that help us do our jobs better. But then he went on to say that he prays about it, and God lets him know that he got it right. And I'm like, oh my gosh, that's just shocking to me that you will believe that you are right, that you are so convinced you are right, and you can't be. I prefer Voltaire's phrase that doubt is a very uncomfortable state or situation, but certainty is absurd. And I realize that maybe people who appear in front of me would wish that I would pretend to be more sure, but I prefer to be honest and just say, I'm not sure. And again, I think that then requires me to be careful and to recognize, time is a really big deal, and judges can't and shouldn't just throw out years of incarceration, years of probation as if it's just another stick of gum, because those are real people, real lives, and I need to be careful. That's what I would say.
Thank you. And Ms. Schlipper, so inevitably you're going to find yourself in a position where you have a lot of discretion and you have to make a decision. Any thoughts about what you plan on using as guidance in making those decisions?
I mean, certainly, what both of the judges have shared, but I think I'm a relatively humble person. And so sometimes I worry about like, oh, will I have a strong enough personality to make these strong decisions? But, in child welfare social work, I used to have to testify in court all the time and actually make recommendations that had huge impacts on whether people should keep their children or not. As a prosecutor, I make really difficult decisions, and I echo what the judges have said, but for me, it's, I have to spend a little time with it. I put a lot of doubt in my own mind. And then if I can come out on the other side of that and sort of after whatever my process is, I guess I'm always questioning it, and I will continue to always question it. And I will never think it's the perhaps right answer, but hopefully it's the rightest answer. It's because I think these decisions are so hard. And when you're impacting people's lives to this degree, it's a continual process. And so I don't have much more to add, but I'm relatively practiced in making these types of decisions, though in a different context. And I don't ever entirely feel like I'm right. And that's an okay thing for me. So, yeah.
Thank you. And I have one last question, and honestly, it's kind of a yes or no question, although there's plenty of opportunity for comment. So do Dane County courts reflect the diversity of the Dane County population? And I will give you a moment to think about it, and anyone can jump in at this point.
Okay, I'll start. Well, if you mean judges, perhaps so, a little bit. Getting closer. Part of the disparity of racial disparity in our court system here in Dane County comes from a relatively low percentage of racial minorities, particularly African Americans, maybe 6-7% African American, but overrepresented in our courtrooms as defendants. Not in our juries. So no, our juries, we are not getting 6% of our jury pool. It's closer to about 4%. And we're trying to figure out how we can increase that. But even 6% is 1 out of 14 jurors. 12 actually deliberate. So no, in terms of juries and defendants, and it doesn't reflect the diversity that it really should.
I think that's true, and also if I think about the people that are prosecuting cases, that office has some diversity. The public defender's office has some diversity. I think the bench has a pretty good diversity, but that is a glaring point that I've had jurors tell me after the fact, was that, why were there no minorities on our jury? And I know it's been studied, and I know that it's a concern for everyone.
Yeah, I don't have anything to add. That's exactly right. Yeah, from my observations.
Thank you. And so, Laura, I know that when we started, we said that we would give the members who are joining us here today an opportunity to ask questions. I know you've been keeping track of those questions. Would you like to?
Yeah, we have quite a few wonderful questions coming in. I will start with the first one, and I will really just read these straight from the chat, so as to not put my own spin on anything. So the first one comes from Marlene. Thank you, Marlene. It says, the community is very angry about teens stealing cars. It is believed that their hands are slapped and then they steal more cars. What are your thoughts about resolving this issue, if you can share your thoughts on that?
I don't think Judge McNamara, you were in a juvenile rotation at any point. I was, so I know a little bit more about the resources, and we talked about this before. So that's certainly part of the issue. You know, it is, if you consider how much turmoil has grown over keeping adults in the jail pending trial, and how much back and forth there is now, frankly, on bail questions. Well, I think it's even more intense as far as keeping juveniles in juvenile detention pending the outcome of their cases. So that's one issue that it's hard to justify in many cases, keeping juveniles locked up, essentially. But also, you have to remember that an adjudication as a delinquent does not share the goals of punishment as much as rehabilitation. And there we get into the resources issue. And I know that the juvenile judges struggle with this issue, with this problem, and with the fact that there are fewer residential treatment centers, fewer group homes, fewer resources when it's appropriate, when that's the need. And quite honestly, there are some juveniles that could probably be rehabilitated more effectively with an incarcerative setting such as Lincoln Hills, but no one, for obvious reasons, wishes to take that step. So it is a problem, and it's a problem that I know the prosecutors struggle with, and the police and the judiciary. And I'm not trying to say it's all because there aren't resources for these people. It's just a lot more of a complex issue than we face when it's in the adult setting and we have the adult resources that we do and those consequences. I know people need to lock their cars. That's also a factor, I have to say.
I'd add that I don't work on the juvenile cases, but I do see very young adults. In Wisconsin, 17 is considered an adult for purposes of criminal charges. And I see 17, 18, 19-year-olds who might have a stack of adjudications or accusations from juvenile court. I don't think it's reasonable for us to deny the community's concern about this, and nobody is, I don't think here, of course, that people are worried about it, and whatever for people who are weekly affected by this, neighborhoods that are affected by just random car thieves that seem to be not for profit, but just for fun or boredom. It's hard for me to determine what's the trigger. But it doesn't seem to be profit. It's not like there's car thieves. The stolen cars that I'm reading about and hearing about in adult cases, kids have taken the car and driven around and then crashed it or something, but they're not selling it. They're not chopping them up like you might picture. But it's not reasonable for us to ignore it. It is a problem. It's just complicated what the solution is. Part of the problem, I think, in the adult system is that we have turned too much to just punishment, when really objective research shows that locking people up in jail or prison is actually a contributor or causal of more crime. It doesn't stop it. It makes it worse. And we can't ignore that either. So we need solutions, and we need to keep talking about it. And on an individual level, being aware, and as Judge Hyland said, maybe trying to be personally responsible is just a reality of life that we all should accept. Yeah.
Thank you. I'll direct this next question first to Ms. Schlipper. What does fairness in a court proceeding look like and mean to you? What do you think makes a fair and impartial judge? And what do you think makes an effective courtroom advocate?
Well, I think being fair and impartial means listening and respecting and hearing all sides of the argument. I have, in some of my spare time, just gone and watched some of the civil courtrooms because that's new to me. And unlike in the criminal world, I think there are a lot of people who, it's one party's represented, one party's not. And so I think as a judge, you have to be fair and impartial and kind of following the law, but get to the right answer regardless of who has the high-powered attorney or who doesn't have an attorney. I think just listening and being respectful and making sure that both sides, again, regardless of the representation, get an opportunity to speak their views. I was watching one artful judge who sort of, it was a child custody matter and the dad was not represented and the mother was, and had a very well-known attorney, and that attorney just kept speaking and was very articulate and not misrepresenting what the father was saying, but the judge stepped in and said, actually, I'm going to let the dad speak, and that's not what I heard, but, very respectful to all sides, and just, I think, trying to get to the right answer, regardless of who's represented by whom. So.
Thank you. Judge Hyland or Judge McNamara, would you like to weigh in on that?
I know that we have an ethical duty to assist people who are unrepresented so that they do have a fair hearing. And I think Ms. Schlipper really, with her observations, hit the nail on the head as far as those types of situations. We see few, but we do see some pro se defendants in criminal cases, and obviously we have to. I don't think the opportunity to be steamrolled is as ripe there as it could be in a civil setting, just because I don't think our prosecutors work that way. I think they know we'd have a real problem if we perceived that they were working that way. But I think for everyone, represented and unrepresented, the first rule for me is explaining it. If you're going to make a ruling, you have to make sure that people understand why. They tend not to walk out of the courtroom feeling more than just disappointed if they understand that there was a reason for the decision. And so you do have to take the time to explain to them so that they know that this may not be what they were looking for, but they understand the reason for it and they feel they were treated fairly and heard. Those are the hallmarks for me.
I don't think it's necessarily original, and it is kind of simplistic, but I personally think crime happens when a person doesn't see the humanity in someone else, doesn't think about the other as a person, and just kind of thinking about themselves. It's kind of a self-centeredness in a way. And that can actually happen between people who know each other or even at some point loved each other. They just don't see a real person there. When the courts don't see real people in our courtroom, it's not a crime, but it should be perhaps. And if we just treat people like numbers or labels, you're not a person, you're the crime you committed. That's wrong. And the same goes for people who are victims of crime. We shouldn't assume that we know what victims want. Most victims, I think, want whatever's happened to them to not happen again to them or anyone else, but they don't necessarily want maximum incarceration or other punitive outcomes. They want positive change. And there's some really excellent recent books about that, like Until We Reckon by Danielle Sarid and some others. But so I think it does start with recognizing that these are people in front of us and listen, as both Ms. Schlipper and Judge Hyland have said.
Great, thank you. The next question is about contested races. This person says, my ballot has only one contested race, and that is MMSD School Board Seat 3. A lack of contested candidates is never good for an open and fair democracy. Can you share any insight as to why all 6 judicial races are uncontested?
I can maybe start this one. I was having a conversation with a woman this morning who, and I was saying, wow, it's really somewhat shocking that, right, because I would be in the contested race as far as the judicial race, most likely, it's an open seat, a judge is retiring, that, word goes out very, very early on and very quickly. And the person I was talking to said, well, not only are you qualified, Diane, of course, but I think, it goes back a little bit to people who want to do this work are typically not politicians. And so what we've seen, especially in Wisconsin over the last several years, has been, I do think, a bit more of a politicized judiciary. And I mean, the last Supreme Court race, I think, cost upwards of $1 million, and the contested circuit court judges races in the ones that were contested, I think were, people were spending upwards of $100,000, and some of it got a little volatile. And I think, the person I was talking to this morning said, I think people are tired. Like, that seems like a lot to sort of want to dip your toes into that. And, I made a decision early on, I can do what I can do. I have to try. This is what I want. If it's going to come down to perhaps money or things like that, it's definitely going to shape things. But I got the sense from the woman I was talking to that, maybe people are just, and it was an attorney who I think at some point has explored the possibility, and it was just, people are tired. And so I don't know if there's any truth to that. I don't know if it's the whole election process and all of the money flowing into it that scares people away a little bit, but it's a couple of possibilities.
I want to jump in. I have a friend who's a school board member at another, and not in Dane County, but another place that's close by. And I can't imagine anybody really wanting to be on a school board right now with all of the issues. I know Ms. Khandhar worked with school issues and kind of knows a little too well kind of as the word Ms. Schlipper used, volatile that those can be. There's a practical issue for judges, which is that traditionally it's only lawyers and law firms that, it's lawyers and law firms that care the most about judicial races. And it's hard to get your partners to agree to let you run against a sitting judge because judges are people too, and they don't want to offend a sitting judge. And now sometimes that's necessary, and that is done. That's what happens. But you do have to be a challenger for an incumbent judge. Takes extraordinary courage, really, and resources, and it's tough that way. That's just kind of a practical reality of it, I would say.
Yeah, and I agree. And I think in some ways, if I look back 6 years to my experience, the 3 people who would have run against each other in theory if there had only been one seat all came from different backgrounds and different experiences and offered different things to the legal community. And I think in the end, when there's enough seats and there's one person interested for each one, I think the pool of candidates is the legal community. Of course, you have to have a law degree to be able to run. I think they size those people up and say, I think this will be okay. I'm not going to put myself out there because of the expense, because of the time, because of the disruption to your practice and so forth. It's a little bit different than the race for school board or county board or the legislature, where you have more clearly opposing views, opposing interests, and a battle between sides to try and control a majority of a body. It's a, you know, we're each a one-person shop. And while I understand the comment, and that if you think of democracy, it seems like you should have competition, you should have a choice. I think it isn't that way, not because any of us are that, you know, we're not God's gifts to the bench, but because the people who would run against have determined that good for you, I'm not going to do it. And I'm happy you're there because you're doing a good job. So that's my theory on it.
Great, thank you. We have two more questions. I do want to be cognizant of the fact that we are at over 7:15, but are our guests okay answering a couple more questions here? Okay, great, thank you. I knew this one was going to be too short. Too short. So as a service representative for survivors of domestic and sexual violence, most of my clients were pro se in civil and family court. DAYS's 2018 Court Watch found that 79% of petitioners and 82% of respondents in Darrow, Harrow, I'm not exactly sure what those are, hearings were pro se.
Domestic abuse restraining order.
Okay.
Restraining order.
So how do you center the safety needs and civil rights of parties who do not have representation in a system that is often inaccessible and inequitable to the most marginalized in our communities?
We have the experience that's being described here when we have our duty week, which happens 3 times a year because every judge shares the 52 weeks of the year. And I know that we're very, and I'm speaking as in everybody does the same thing, but I think everybody does recognize that you're dealing with 2 individuals who, as Judge McNamara was saying before, someone's done something to someone and they are very much at odds, and they both have a right to a hearing and to be heard. But you have to conduct that hearing in a space that's safe for both of them. And you have to ensure that there is not the opportunity physically, and our bailiffs do that, to make sure there's contact. And even during the hearing, making sure that things are directed towards us, not to the other person. It's not easy. Some judges do it differently, I'm sure, than others. But everybody, I believe, is very tuned into the fact that you have people that are there because of this conflict and need to be treated carefully and appropriately and given the right to their hearing, speaking within those injunction, temporary restraining order settings.
I would add that although I'm sure the day statistics are absolutely correct for 2018 and at least correct even for now, at least that high. Not all of those are contested. And if they are contested, very often, of course, both parties are unrepresented. And I think Judge Hyland mentioned it before, you have to be able to explain your decisions. And if it is a contested decision, that means one party will be disappointed with the outcome. And so we do need to be careful to explain. And I don't mind actually those duty weeks. I mean, some of the issues are unpleasant. I hate it. I do hate when parents have submitted restraining orders on behalf of their children against another child at school. There's like a complete, something really is going bad there. But those, we do get those from time to time. And sometimes it's necessary, perhaps. I mean, I know bullying is a real thing. I don't mean to disrespect that reality. But explain it. You know, this is a bigger problem of unrepresented parties on eviction cases, where if landlords are not represented, they're very often repeat parties in cases with a degree of sophistication or savvy even in front of the court, versus a tenant who is probably going through an eviction process for the first time, or and just is not represented. And those are hard challenges as well, because again, we have to remain neutral and follow the law, but sometimes following the law means that we can act within our discretion in ways that might disappoint one side or the other, including landlords sometimes or represented people sometimes.
It's interesting because my experience through duty weeks has been that I think it's much harder if one side in an injunction or a temporary restraining order hearing, domestic abuse, et cetera, is represented, because I feel like then I really have to be cautious and careful about protecting the unrepresented party, because it's really easy to let the attorney just beat up on them. And if both sides are represented, frankly, it's even worse, because you're kind of caught between wanting to give the attorneys their opportunities, but at the same time, that can be really grueling for the two participants that are there. I'm never happy when I see attorneys at that in those cases for that reason, because I know that I'll run the hearing in a way that allows each person to state their case without feeling like they're being traumatized. I actually even go to the extent of saying, if you have questions for the other person, tell me what the question is and I'll decide whether I ask it or not, because I think even examining each other can present that problem. I don't think everyone does it that way, and I don't advocate that for anybody, but I think it's a protection we can try and exercise in that setting.
Thank you. So our last one goes a little further into this. How do you balance social justice in cases involving minors who are victims of child sexual abuse, child abuse, neglect? For example, when court proceedings are continually delayed over years and increasing multiple requests for alleged offenders to lower bail or change attorneys impedes a child victim's mental health progress and their ability to have closure. That's a big topic.
I'm having a bail hearing tomorrow in just such a case, and I think because the individual has sat for more than 2 years for lots of reasons, including the pandemic, but also issues with changing attorneys, some of which has been the defendant's problem himself. And now I'm going to be looking at and saying this won't be tried until next fall. I really have to genuinely consider whether it's time to allow that person release. And I know there's an objection from the family of the child victim. We have to balance the constitutional rights of defendants and the rights to bail that our statutes present in each and every case. And quite honestly, it is brought to our attention all the time about what impact this is having on the alleged victims, and especially if they're children and their families. And we have to take those things into consideration. But if you look strictly at Marcy's law, it says that nothing in that law supersedes a defendant's rights under the Constitution. So it presents very difficult decisions. And I don't know, I think Judge McNamara does the same. Child victim cases get a priority unless someone has an in custody status that is older. I mean, they go to the top of the line for that reason, at least in my structuring.
I wouldn't add anything to what Judge Hyland just said. That all of those points are exactly right.
Great. Well, that brings us to a close. Panelists, thank you so much for being with us tonight. I learned so much, and I hope that our attendees also did. So thank you also to everyone who joined us today for the conversation. I would be remiss if I didn't just put out a huge reminder that Wisconsin's next statewide election is coming up on Tuesday, April 5th. If you have questions about the upcoming ballot or voter registration, the website myvote.wi.gov is a great site to reference. If you have the right to vote, we encourage you to please exercise it. Use your voice to stand up for those who do not have that right. A reminder that our Just Conversation series continues each month on the fourth Wednesday. Keep posted on these events and more of what JustDane is doing by following us on social media. We're on Facebook, Instagram, Twitter, and LinkedIn. And we will be sharing more information about upcoming events through those channels. Thank you so much again for spending your Wednesday evening with us, and we hope you have a lovely rest of it. Goodbye. Thank you.
Thank you. Thank you all. Bye.